All right, we do this case just to sort of extend the right to privacy a little bit. So we've jumped forward 12 years, Justice Brennan writing the opinion of the court. So New York had a law in the books which prohibited the distribution of contraception to those over the age of 16 by anyone but a pharmacist, and it prohibited sales or distribution of contraceptives to anyone under the age of 16. Now, why is this important? It's because this law in question does not deal with just marriage. Remember that Griswold deals with marriage exclusively. So conception within the confines of marriage is a privacy right. But that right didn't extend to anyone who wasn't married. It certainly age wasn't a factor. And so the court takes up this case and ultimately reads in a much more holistic viewpoint. So the issue in this case is, does the right to privacy, which extends to the right of contraception of married individuals, also extend to the right of contraception, right to access to contraception more holistically? And the Supreme Court holds that these types of laws are patently unconstitutional. The state can't restrict access to contraception on the basis of age or on the basis of marital status. It's even more shocking because the argument that the state of New York puts forward in this case is so amazingly antiquated, even in 1977, but we hear it today as well, and it's still as amazingly antiquated. The argument that the state puts forward is that, well, we banned contraceptives for individuals under the age of 16 because if contraceptives aren't available to them, they won't have sex. Which I can't roll my eyes hard enough to tell you how stupid of an argument that is for the state to make, because it's exceedingly stupid. So they saw this, the limiting of contraception, as a way to decrease teen pregnancy. That's a logical tornado of dumb. And I'm not exactly sure how the state gets there. So in this case, the court reads this right to privacy, this right of access to contraception, to go beyond the marital confines. There is a dissent in this case, and it's a doozy. And it doesn't deal with explicitly substantive due process. Justice Rehnquist dissents in this case. The argument that he puts forward in this case is old man yelling at cloud, is the best way that I can describe it. Justice Rehnquist dissents, stating that, well, if the patriots who died in the Revolutionary War and those responsible for the Bill of Rights could see the effect of their work, they would not believe at all that the Constitution protected commercial vendors from selling contraceptives. Okay. As I started off the beginning of the class with, there's an argument that, well, the founders never would have wanted to see D.C. as a state. Well, that's probably true. The founders also didn't want African Americans to vote. They didn't want robust rights for women. There are a number of things that the founders didn't want, the creators of the Bill of Rights didn't want, that we recognize in 2021 are generally good things and things we can all agree upon. Invoking the founders to make an argument is not exceedingly persuasive unless their intentions are very clearly known. And the answer in this regard is they're not. And so Casey and Carey have to be read in conjunction with each other. They really are together in what they lend. Griswold takes the first step and says contraception is legal within the confines of a marital relationship. And Carey, 12 years later, says that no, contraception is just a right. Contraception and access to contraception is a right that individuals retain. Substantive due process is not even really invoked in this case, and there's no real reason for it to be. 12 years earlier, it wasn't. When the court carved out a right to privacy that included access to contraceptives. So 12 years later, when the court is simply extending that access to contraceptives, they don't invoke it either. And it's interesting to note that even the dissent doesn't invoke it either. So within 12 years, the notion that the really problematic part of Griswold is the fact it uses substantive due process doesn't even come up in Carey.